The Punjab and Haryana High Court reprimanded real estate company MS Orris Infrastructure Private Limited and Union Bank of India for illegally removing the title deeds of chunk of land worth crores of rupees lying in a bank locker. This locker was to be jointly operated by Orris Infrastructure and another real estate giant MS DLF Home Developers Limited. It has been alleged that without the finalization of the arbitration proceedings regarding the disputes between the two real estate companies, around 40 acres of prime land in Gurgaon, Orris Infrastructure, with the connivance of bank officials, illegally removed the title papers of the land. We are of the considered opinion that a gross illegality was committed by Orris Infrastructure collusion with the Union Bank of India by removing the title deeds lying in a locker which was to be jointly operated by the parties. We are all obligated to abide by the rule of law, and under no circumstances can anyone be permitted to take the law into their hands, the High Court said. A division bench comprising Justice Arun Palli and Justice Vikram Agarwal passed these orders while hearing a plea filed by MSDLF Home Developers Limited. The bench further observed that Oris Infrastructure and Union Bank officials acted as if the award became final and that whatever was held therein was not subject to challenge. In our considered opinion, the Commercial Court Gurgaon also erred in not turning the clock back and restoring parties to their original status, the bench held. The facts of the case were that there was a collaboration agreement of 40,084 acres of land between MSDLF Home Developers Limited with MS Oris and other entities. Dispute arose between the parties and the matter was referred to arbitrator. Wide award dated 15 July, some relief was granted wherein they were entitled to the title deeds which were jointly kept with Union Bank of India. After award, an application for correction was moved on 30th July by MSDLF, and in the meantime MS Oris approached the bank for the operation of the locker for the removal of the title deeds. As per the award, directions were to be complied with by the parties within 30 days. The dispute, which came to the High Court, arose out of a petition filed under Section 9 of the Arbitration Act restraining MS Oris from getting the title deeds released from the Union Bank of India pertaining to 14,084 acres. The contention in the petition filed by DLF through senior advocates R.S. Rai and Chetan Mittal was twofold. Firstly, that even before the expiry of 30-day time, MS Oris approached the bank via a letter dated 5th August 2024 for the release of original title deeds. And secondly, there cannot be piecemeal enforcement of the award, and action of MS Oris was premature as the award had not become final unless 90 days expired as per Section 36 of Arbitration Act. After hearing all the parties, court observed that this act of removal of deeds without waiting for the end of statutory period was grossly illegal and called for highest level of condemnation and depreciation. The bench further directed Oris Infrastructure to immediately place back all title deeds which were removed from the joint locker. The court has also asked the Commercial Court Gurgaon to decide the matter between the parties within 3 months.